Ladies and gentlemen, Property Mentor welcomes Sally Lawson.
Okay, I hope you've all had a good night's sleep now, because we're now getting to the little bit, okay? Now, I'd like to keep it as light-hearted as we can, and there'll be an opportunity for questions at the end, so if you've got any burning questions, please keep it to the end. All I'm going to do is, this is a culmination of 18 months training program in 1 hour. Okay, so you're going to have a fast track to qualification, okay? And obviously all I'm doing is skimming over the most important bits. These are the bits that as a landlord you absolutely must know. And if at the end of this session, if you take away from this that when somebody says something, be that a tenant, another landlord, an agent, and you think, oh, there's something I need to know about this, and you go and look it up, you've achieved something. Because you cannot understand all the regulations and legislations, etc. You just need to know the basics, and that's what I'm going to go through today. Okay, now first thing I want to talk to you is about, do we all know about the law of the land? Yeah, we all know that if we enter Thailand with a load of drugs in our case, that we could get done for it, don't we? Yeah, because the law of the land says you can't do that. And there's lots of laws of the land, and in this country here's a few of them. Not to kill, not to steal, got to drive on the left. If you decided you wanted to drive on the right, we might have a bit of a problem. Not to sell alcohol unless licensed, and contracts have to be fair. Any other funny laws or regulations that you guys have heard of? Any weird ones, weird and wacky ones?
Do not fart, that latest one in. What is it again?
Do not fart?
Yes. Yes, Malawi.
Malawi, you can't fart. Fantastic. Another one at the back? No farting? Say that again. Okay, you can take the deer home as long as you didn't kill it yourself. Is that this country? Wicked, I'll remember that. I'll get my son to run it over, okay? This one?
You can shoot like a Welshman, but only through the eye with an arrow between certain hours.
So you can shoot a Welshman. There's no Welshman in the room, is there? You can shoot a Welshman through the eye with an arrow, but only at certain hours. Fantastic. Any more?
No chewing gum on the pavements in Singapore.
No chewing gum on the pavements in Singapore. Remember that one? Okay, fantastic. Here's a few I picked out. It is an act of treason to place a postage stamp bearing the British monarch upside down. Act of treason equals death. Be careful with that one. It is illegal for a cab in the City of London to carry rabid dogs or corpses. I think there's a few guilty of that. It is illegal to die in the Houses of Parliament. What are they going to do about it? In Lancashire, no person is permitted after being asked to stop by a constable on the seashore to incite a dog to bark. Weird. And in Chester, I think this might come back to this one, Welshmen are banned from entering the city before sunrise and from staying after sunset. Dear me, some scary ones, isn't there? Okay, so that's just an idea. These are law of the land. Now, of course, we don't know about these. They're ridiculous ones, but they are there. They're still there, and they've not been taken out. But there's a lot more that we do need to know about, okay? And I want you to understand here the difference between law of the land and law of contract. This is what we're going to be examining now, okay? You've got law of the land. These are some of the things that we talked about with law of the land. And as we said before, contracts have to be fair. Anybody here deal with contracts in their day-to-day business work? Yeah? Now, most contracts we come across, there's going to be three things. For a contract to be legal in this country, there has to be three things. There has to be an offer of something. I offer you my house, I offer you my car, I offer you a room in a hotel, whatever. There has to be an acceptance. I accept to take the car, I accept to take the house, I accept to take the hotel room. And there has to be a consideration. For that, I agree to pay £10 a month, £1,000 a month, £5, whatever. So there has to be an offer, there has to be an acceptance, and there has to be a consideration. So therefore, me and this gentleman here, which is Phil, we're going to have a contract now, me and Phil. You ready for this, Phil? Come on up, I want to sign your life away. We're going to do a contract, okay? Don't be too scared. This is on camera. Okay. I, Sally Lawson, give Phil... What's your last name, Phil?
Whaley, W-H-E.
You sure? Do you want me to put a different name down on here? W-H-E...
E-A-L-Y.
Okay. I, Sally Lawson, give Phil Willie consent to kiss the Queen on her next visit to wherever we are. And for this, we're going to agree a fee of £1. So we're going to pretend Phil's just given me £1. There we go, agree £1. I'm going to sign this now. There you go, Phil, if you can sign that for me. Now, this is a contract. we have an offer. Thank you very much, Phil. We have an offer of I'm giving Phil consent to kiss the Queen. We have an acceptance. He agrees. And we also have a consideration for £1. It's dated. It's signed. Question is, do we have a valid contract? Why not?
Queen is not a party to it.
Queen's not a party to it. This is true. Anything else?
Is there intention to create legal relations between them?
Okay, that's a big one. Is there intentions to create legal relations between us? I don't know about that one. I'll have to pass on that one. At the back?
I witnessed the signature and it's the 19th today, this is the 18th.
Oh, okay, right. Yes. Must focus on the paperwork.
Can it be enforced?
Can it be enforced? Good point. Can it?
Is it capable of delivering?
Is it capable of delivering? Absolutely. No, it's not, is it? No, it's not enforceable. No, it's not capable of delivering. Do I have the right to give that consent?
No.
Absolutely not. So is this a valid contract? But it's got an offer, an acceptance and a consideration. It's got all the legal requirements for it to be a legal contract, hasn't it? Yeah? It has. So why is it not legal? It's one reason. Because contract law cannot overrule law of the land. Thank you, Phil. We'll put a line through this just in case anybody thinks it's strenuous. It's not. Okay? Contract law cannot overrule law of the land. That is so important that you understand that. Because this is where a lot of landlords get it wrong. Law of contract. Law of contract can only be in place where there is not statutory law that says otherwise. And therefore, if you create a tenancy agreement, let's think about tenancy law now. You've got a tenancy agreement and you know that you've got to give your tenant 2 months' notice. Is that right? An AST? So if you put in the contract that you only have to give 1 week's notice, is that valid? Why not? Contract cannot overrule statutory law. You've also got a few other things you've got to bear in mind as well. That you've got to make sure that the contract is fair. We have something in this country about unfair terms. If you create a contract that's unfair. So, for example, if you put in your tenancy agreement that the tenant must wash up by 6 p.m. every evening, is that fair? No. I actually had a landlord a few years ago, before Dawn's time, if you remember this, we had a landlord a few years ago that used to go in and peg out the tenant's washing for him every day because it used to annoy her that he left the washing in the washing machine. It drove him mad. That broke so many regulations, but, it drove him mad. But it's unfair to insist on things that, the tenant has a right to live there as he wants to live there. As long as it's not damaging your property, he has the right to live there as he wants to. So you've got an obligation to make sure it's fair. You as landlords have an obligation to understand enough of the law to make sure that your contracts are fair, clear, because you've got unclear terms. They've got to be fair, they've got to be clear, and they've got to not contradict statutory law. Okay? There's 2 different types of tenancy. You've got common law contractual tenancy, and you've got Housing Act. Now, we've all heard of assured short-term tenancy. Has anybody not heard of assured short-term tenancy, or ASTs as Martin calls them? ASTs? Great, we've all heard of them. Okay. Now, there's a few things you need to look at. When you've got a tenant in front of you, and they want to rent one of your houses, you've got a few questions you need to ask yourself. And these are 3 things that you should be able to know off by heart. You should be able to know them off pat. Our staff certainly do. Number 1, the tenant must be an individual. Is the tenant applying for your property a person? That sounds silly. But are they a company, PLC, limited company, etc., charity? Are they a person? If they are a person, that's one step towards being entitled to a Housing Act tenancy, or AST. Second question you need to ask is, have they got exclusive possession? Now that can be exclusive possession of one room, or it could be exclusive possession of a whole house. But have they got exclusive possession? Do you have the right to enter that property or not? Third question, is it their main or principal resident? If somebody's renting it as a bit of a pied-à-terre or weekend pad or just stopping a couple of days during the week but he's got a wife and family and kids elsewhere, then the answer is no. Is it their main or principal residence? And those are the main 3 things you should ask yourself. You should also know whether you're resident as well. Because if you're living in the property, then they're not entitled to a Housing Act tenancy. So those 3/4 criteria are the most important things that you should know. And these are things you've got to ask yourself when you have a tenant in front of you. Now, what is common practice is that landlords think that if they put this in the contract, that you can give a week's notice, that they've actually got a license agreement, and therefore they can get them out with the 7-day eviction method, whatever that is. That's what they've got. However, in law, if the tenants meet that criteria, they've actually got a what? An AST. They've got a Housing Act contract. And basically the two types of contracts here fit into two criteria. Housing Act means they have all the protected rights of a Housing Act tenancy. They have all the protected rights of the Housing Act 1988, which came into effect, you need to write this date down, guys, 15th of January 1989. That is the day the world changed for lettings. 15th of January 1989. Diane's laughing at the back there because she knows this stuff parrot fashion. So you've got to make sure you know. Okay? So, do they fit the Housing Act tenancy? If they do, they are entitled to an assured short-hold tenancy. However, if they don't fit that criteria, then they're entitled to the other side, which is a common law or contractual tenancy. That basically means a type of tenancy that isn't a Housing Act contract. So in that you've got various different types. We call them all sorts of things. We call them licenses, we call them holiday lets, we call them student lets, we call them commercial lets, agricultural lets, company lets. You've got all different types of different lets there, but they all fit this criteria. And what that means is all these people down here, so if a limited company rents a property from you, or somebody who's only got it for 2 days a week rents a property from you, or they haven't got full exclusive possession of that house and they rent a property from you, that room or that house, then they don't have all the protection of the Housing Act 1988. So all those ASTs, Section 21, Section 8, 17 grounds for possessions do not apply if that tenant does not fit that criteria. So you've got to ask yourself one very clear question: which side are you on? Now later on today, I'm going to actually put some forms out, and if you give us your email address, I'll email over to you a tenancy agreement checker. It's like a flow chart. And you can just go, is tenant an individual? Yes. And you can go down, and it will tell you what type of agreement you should actually be using. But as landlords, you need to know that. And what I found on my worldly travels as a mentor and consultant with my letting agent friends is they tend to have favourite types of contracts, and they just use that for everybody. But that's not the way it should be. You've got to use the right contract for the right tenant. Now, what happens if you've actually signed all your tenants up on a licence agreement or non-Housing Act agreement, and you therefore give them 1 month's notice, which is required in the Protection from Eviction Act 1977. So you give them 1 month's notice because you've got a licence. You don't need to give them 2 months' notice. What happens? I want you to park that question because we're going to come back to it later. Okay, so there we are. Those are the criteria. And I'm going to put a question in front of you now. See if you can answer this one. I'll read it to you because you might not be able to see it. This is called the Forfeiture Clause. And this clause is in most assured short-hold tenancy agreements. But I want you to look at this and see what you think. The landlord has the right to automatically repossess the property, subject to his statutory rights to do so, in the event of the tenant becoming 14 days in arrears, whether legally demanded or not. That is in most assured short-hold tenancy agreements. Why? What is it saying? What would you think it says reading that?
You can go in after 14 days and take the house, but obviously can't.
Absolutely. So what they think it says, most people that think it says, is that when the tenant's 14 days in arrears, I can go and kick them out, can't I? Do you think anybody's ever done that? They have. There's been plenty. Because what we do in the way we read things is the way we read that is the landlord has the right to automatically repossess the property in the event of the tenant becoming 14 days in arrears, whether legally demanded or not. We read it like that because we don't understand what that paragraph bit means. Have you ever read a contract where it says you are committed to give 2 months' notice subject to subsection 2.14 as stated later in this contract and with regards to such and such act, etc. And you read that. Do you ever go and have a look what subsection 2.14 actually says? No. We just think, oh, it says I've got to give 2 months' notice. But subsection 2.14 might actually say you haven't got to give any notice. Mightn't it? And that's exactly what's going on here. Subject to his statutory rights to do so says what? Look at the law. What it is saying is, and if you look at the law and you know the law, it says you can't get them out with 14 days' notice. You've got to give them 2 months. So you've got to be so careful with what you read. And what I really want to home in here, no matter what you put in a contract, statutory law prevails. If you've got to give 2 months' notice, you've got to give 2 months' notice no matter what you put in your contract. This is a forfeiture clause. I think it makes tenants think you can get them out after 14 days. But You can't at the end of the day. So be careful what you read, understand what you read, and always understand the brackets. Now, what we have an obligation as landlords is to make sure that our terms and conditions are clear. It should say in your terms and conditions exactly what grounds for possession you can get possession on. It should say exactly what notice you've got to give. You should make sure your terms and conditions are very, very clear. But I find this very, very confusing as a clause. And certainly a lot of people have been evicted after 14 days because of this. Okay, provision for statutory tenancies. Now, if you know the Housing Act 1988, what you will know is that the Housing Act 1988 came into effect on the 15th of January 1989. What this meant was that from that point onwards, tenancy agreements could now be written under the Housing Act. So they became the Assured Short-Hold Tenancy. The Assured Short Tenancy, the AST, was born. This is revolutionary. Have we got any landlords that have been around since before then? A couple? So you can remember the protected and statutory tenancies before then. Protected and statutory tenancies, tenants could stay in your property for years. They could pass it down to their children. I'll give you an interesting stat here. It's not in the slides, but in 1900, time of Scrooge and Scratchit and all that sort of lot, 1900, the private rented sector, that's the amount of properties that were rented in this country, was 90%. 90%. Have a think what it was like in the 1900s. Did you have to serve a Section 21 in 1900 to get your tenant out? No, just changed the locks and kicked them out, didn't you? Now, they brought out numerous acts and regulations to protect tenants, including the Protection from Eviction Act in 1977. And landlords just said, you know what, I'm not going to give my house to this tenant for their entire life and so allow them to pass that down to their children, etc., etc., because they just can't get the property back. And so they decided not to rent out. And by 1987, have a guess what the private rented sector was at. What percentage were we at? It was 90%. It's gone down. Where did it get to? Any guesses? Come on, guys. Sorry? 10%? Lower? 6%? Higher? 7. It was 7%. 1987, the private rented sector was 7%. Now, what was the world like in 1987? Margaret Thatcher? Arthur Scargill? Miners' strikes? Massive unemployment? 4-day week? 3-day week? It was a strange place. Margaret Thatcher realised that in order to get these people off the dole, they had to improve the private rented sector. Because if you're renting your house, you could move to where the work was, couldn't you? So they put the Housing Act into Parliament. They spent something like 250 hours debating it, and they brought out the Housing Act 1988, which came into effect the 15th of January 1989. And it completely turned the housing sector on its head. The AST was born, and what it meant was now as landlords, if you want your property back, you can get it back. Isn't that good? And I think that's why we're all here, because we probably wouldn't be here if it wasn't for that. So this is a really important thing. Something to bear in mind though, guys, if you're buying a property or looking to buy a property, just have a think about those dates. If you've got a tenant been there 30 years, start asking some questions. Anyway, so what does it mean? First of all, when the Housing Act first came out, you had to do a tenancy agreement for a minimum of 6 months. Now, they revised the Housing Act in 1996, and there is now no minimum term. So you can do a tenancy agreement for 1 month, 2 months, 3 months, 2 weeks, whatever you want to do. But there is a problem with that, and you need to be aware of it, in that if you do a tenancy agreement for 3 months, you can't actually gain possession until 6 months. So do you want to do a 3-month contract if you absolutely need that property back? Nope, because you can't guarantee to get it back. So just bear in mind, although there's no minimum term, there still is a minimum period of 6 months before you can issue your Section 21. Now, when the Housing Act first came out, all contracts were as standard something called an assured tenancy. Assured tenancy is the same as assured short-hold tenancy, sort of, but you don't have the right to serve a Section 21. So you've got more security of tenure. Now, this was easy to solve. All you had to do was serve a Section 20 notice. Anybody remember Section 20 notices? Not many? Okay. Section 20 notice is a very simple-looking piece of paper, and it just says the contract you're about to enter into is an assured short-hold tenancy. Sounds quite simple, doesn't it? How many landlords do you think forgot to serve that piece of paper? What sort of contract did they create? Assured tenancies. Can they get their tenants out? No. So Section 20 notice, if you're buying a property that is post-1989 and is pre-1997, when the 96 regulations came into effect, 20th February 1997, you've got to have a Section 20 notice in your file. If there is no Section 20 notice, speak to a solicitor. Okay? So, originally, all contracts had to be an assured tenancy. You had to serve a Section 20 notice to create an assured shorthold. And then 28th of February 97, all contracts were automatically now, and as it is now, an assured shorthold tenancy agreement. So we don't have to serve a Section 20 notice anymore. But when you're buying properties, be very aware of that. Simple things like that, as we say, the paperwork can cause you a lot of problems. Also, when the Housing Act first came out in 1989, the requirement for issuing of a Section 8 notice, which is the name of the notice that you serve to get the tenants out if they're in arrears, they had to be 3 months in arrears, not 2. Now, this was changed in 97. It's now 2 months in arrears, as you know. But if you're buying a property again where a tenant has been there since pre-97, bear in mind it's 3 months in arrears. So something to bear in mind and consider. You've got the Section 21 to gain possession. That was brought out in the Housing Act 1988, so that's fine. We've got that. We know that if we want to get our property back, we just issue a Section 21 notice, give them 2 months' notice, and they have to be out. We'll cover that a bit more in a bit. And also they gave us 17 grounds for possession. How cool is that? They originally gave us 16, and they added a couple, as in 14A and 17, when they revised the Housing Act. But those guys are 16/17 grounds for possession that you can get your tenant out on. Do you know what they are? If not, be aware they exist. Go and have a look. The most commonly used ones are ground 8, 10, 11. Those are the rent arrears ones. We'll talk about those a little bit further. Okay? So those are just a few things that you need to be aware of. We're all okay? We're not falling asleep yet? Okay. Need some more silly laws to wake us up. So we've identified which tenants actually have assured short-hold tenancy agreements and which ones can't have assured short-hold tenancy agreements. What we are talking about now is all the rules, regulations and provisions that are in place for assured short-hold tenancy tenants. Okay? Now, with an assured short-hold tenancy tenant, when you want to get them out, you've got two routes. Section 21, which is commonly known as the no-fault notice. They've not done anything wrong, you just want your property back. It might be because they've done something wrong, but they don't need to. And Section 8 notice. Section 8 notice is when you want to use one of the grounds to get them out, which means they've defaulted on something, they've done something wrong. Not always, but generally it means they've done something wrong. It's a Section 8 notice. And Section 8 just is the name of the notice that you use to say to the tenant, we're going to be seeking possession because you've broken grounds 8, 10, 11. And there's 17 grounds in total now. And what you need to be aware of is that some of those grounds are what's called discretionary grounds. Some are mandatory and some are prior notice. You're not going to remember all this stuff, guys, but just think, oh, I need to think about something here. There's three things: mandatory, prior notice and discretionary. Now, if you want to use one of the prior notice grounds, which is like there's a mortgage on the property and they're repossessing, or you used to own the property and live there and you want to move back in, or there's a minister of religion and you need it for that again, whatever. If it's one of those, that's not where the tenant's done anything wrong. But those are where you have to have served notice on the tenant before they moved in that you may require to use that notice to get them out. And that's why it's called prior notice. If you've not served notice on them before they move in that you may use one of those grounds, you can't use them. So just be aware of that. The discretionary, which is 9 to 17, these are things like the tenant's damaged the property, the tenant's damaging the furniture, the tenant's a little bit in arrears, they're persistently late, those sort of things. All these grounds are all there for you. You don't have to know them, but just make sure they're there, or just be aware that they're there rather. These are called discretionary. What does discretion mean? There's a choice. And it's the choice of the judge, the court. There's a choice of the court on the day as to whether they grant you possession. Now, discretionary grounds are not used very often on their own. They're usually used as tag-ons to mandatory. Because what does mandatory mean? Has to. The judge has to award you possession. The court has to award you possession. If your paperwork is right, if you've done everything right, and you go to court and everything is as it should be, the judge has to award you possession. So do you want to go to court on a bit of a, well, it might work, it might not? Do you want to go through that hassle? All that expense, that time, upsetting the tenants, etc.? Probably not. But if you've got a mandatory ground and you can tag a few discretionaries on, do you think it'll add to your case? Absolutely. So never just use one mandatory ground. Tag a few other ones in as well. Helps the case. For example, the most commonly three that we use, I'm just moving over to the side of the room, the most common three that we use is Section 8 serving grounds 8, 10 and 11. 8 is that they are 2 months in arrears, 10 is that they're in arrears, and 11 is that they're persistently in arrears. Those three grounds are the most commonly used three grounds. Now, why do we serve 10 and 11 as well? Why? They're 2 months in arrears. Reinforce the point, it does, absolutely. But there's another reason as well.
Follow the process, you've escalated it.
Follow the process and escalated it, it would certainly help with that, yeah?
They might pay the arrears.
Absolutely. Clever tenants will pay a few quid just before you get to court. So you're 2 months in arrears, £1,000 a month, £2,000 in arrears. The day of court, the tenant pays 50 quid. They do this. You're not 2 months in arrears anymore, are you? And you have to be 2 months in arrears the date you serve the notice and the day you appear at court. So you're stuffed then, aren't you? But if you've served 10 and 11, you can go to the judge and you can say, look, this guy's been in arrears for years, he's persistently in arrears, persistently late, he's been 2 months in arrears for so long, he's just paid 50 quid this morning, but, you know, I'm really in deep trouble, I can't afford my mortgage, this has got to be sorted, etc., etc. You've got a very good chance of getting a possession. Whereas if you hadn't served 10 and 11, you probably wouldn't. Okay? So remember, use a mandatory and tag on a couple of discretionary. You can go purely on discretionary, but you may end up just losing your tail and walking away very disappointed. Now, you've got to be aware as well with Section 8 notices, they've got to be served in the correct manner. You can do this by hand. You can also do this by post. They used to say do it recorded delivery, but they don't anymore because people tend to not take it. So it's best to do it by post or do it by hand. And if you're thinking this is going to go to court, which is more likely the case, if you go on to courtservice.gov.uk, which is the court's website, that's courtservice.gov.uk, and download a very simple form called a Certificate of Service. It's just like it's like a pledge almost. Sally Lawson did post this through the door of such and such on such and such a date at this time, etc. It's like your sort of witness statement. Put that in the file, so when you go to court, you've got your certificate of service ready, saying that you've actually served that notice on that date and that time. Just proving the point. Now, with the Section 8 notice, when you're serving notice on the tenant regarding the grounds, something you've also got to be aware of, I'm not going to go through it today, but there's different notice periods. If you're going to kick your tenant out for arrears, it's 14 days. So you serve that Section 8 notice, and you give them 14 days. You say, look, we're going to take it to court if you don't pay in 14 days. You allow 2 days for service, so it's effectively 16 days, and then you start the court process. Get this stuff in your diary. 2 days in arrears, bang, Section 8 notice. 16 days later, court papers gets taken into court. Take them up to the court. Get the court manager to check them to make sure that you filled them out right. Because if not, you'll be going in the court system for weeks. Just go up there, make sure they've checked everything's right, and get the court action started. It's a very simple process, and the court manager will help you, and so will the website as well. All the stuff on courtservice.gov.uk is there for you. And the actual courtroom, it's just a little room with a man sitting there with a recorder. The tenants hardly ever turn up. It's a very simple process, so just make sure you're very, very timely with it. But if you were going to use one of the other grounds, there's all different notice periods. Some are 2 months, some are immediate, one's immediate. So you've just got to be aware there's different timescales. I'm not going to go for that now. Just check it out before you do it. So here's a question for you then. We know that Section 20 notice, we have to give 2 months' notice. We all know that? Yeah. So we've got, hi, Mr. Tenant. This is what, is it a letting agent or is it, what? Let's say it's a landlord, okay? Hi, Mr. Tenant. Here's your 6-month tenancy agreement. They're in there signing for their move-in date now. If you'd like to sign this and your inventory and statement, could we also serve this Section 21 notice? It's just to say that we may wish to have the property back at the end of the tenancy agreement, but if you or we're happy to renew, we'll send you a renewal contract. 5 months later, a letter is sent to the tenant saying, subject to the notice given at the beginning of this tenancy, we require possession at the end of the month or in 1 month. Question is that fair or not fair? Do you know that's one of the most common practices that we come across out there on the circuit? Why? People do it because they think, well, I can get the tenant out a lot quicker. If I've already served that Section 21 notice at the beginning, when it comes to the end, I can just say, oh, mate, you know that notice we served at the beginning, we want you out now. The question is that fair? Is that within statutory regulation? Or is that trying to take away their rights? Would you say it's trying to take away their rights? Absolutely it is. Now legally, as long as you serve that Section 20 notice after they've signed the tenancy agreement, that's absolutely fine. If you absolutely want that contract back and you want that property back at the end of 6 months, there is absolutely no problem you serving a Section 21 notice the same day they sign the tenancy agreement if you want that property back. There is a huge problem, however, if you're serving it in case you want that property back, because are you being clear to the tenant? Is that fair? And so you've got unclear terms, unfair terms. So don't do it. Only serve that Section 21 notice when you actually need to serve it. And remember, you've got to give 2 months' notice. And that Section 21 notice can't end before the end of the contract. Okay? Common practice, that one. Comes up every ALA training course we ever go to. It's quite hilarious. We always sit there and someone comes up, oh, well, we always serve a Section 21 at the beginning. And we'll just duck under the seats, don't we, Dawn? Think, here we go. And the teacher goes, you do what? And think, oh, this is going to be so much fun. Okay, so there you go, Section 21 notice. There's 2 different types of Section 21 notice, do you know that? Section 21(1)(b) and Section 21(4)(a). The way I remember it is it's the wrong way round. B comes before A. So Section 21(b) is for a contract that hasn't expired. Section 21(4)(a) is for when it has expired. I wouldn't worry too much about that, guys. Just get somebody who's a bit more knowledgeable or somewhere to download it for, and it should tell you which one to use. But just remember, there's 2 types of Section 21. You've got to make sure you're using the right one and get it served on your tenant, giving them 2 full months' notice. If you're serving it after the expiry of the contract's expired, you need to serve that from a rent date. If you serve it before, then you don't. But we're not going to cover too much about that just now. Okay, so you've done your Section 8 notice, you've done your Section 21, you might serve both. In some cases, you can actually serve both types of notice. There's no reason why not. You're then going to apply to the courts. You might say you've served a Section 8, Section 21, or both, but you go to the courts. This is what you need to take with you. Do not be scared of the court process. It's not that difficult, but it is only going to be as easy as your paperwork. If you've not kept copies of your paperwork, if you've not got everything you should have, you're in trouble. But if you've got your paperwork sorted, the rest is easy. You're going to need a copy of the AST signed by the tenant. You're going to need a certificate of service that we just mentioned, which you download off courtservice.gov.uk, just to say that you've actually served that notice and when you served it. You're going to need a full ledger statement. That's a statement of everything they've paid, everything they were due to pay, and everything they've not paid. The judge will ask for that. You need a copy of the notice or notices that you've served. And you'll need the court papers and particular of claim. You've got Form N5, which is the usual one that you can use. If you just go onto courtservice.gov.uk and type in possession of property, you can download the form off there, just fill it out. Particulars of claim, you can just download that, fill it out. And you need to send all those things off in probably duplicate or triplicate, because if you've got 3 tenants, you need 3 copies for each of the tenants. Sorry, 1 copy for each of the tenants, which equals 3 copies. And you need a copy for the court. You send those off. Keep the originals yourself. Please don't send off the originals, because courts lose stuff. And also send off the court fee. Send it off to the court. If it's your first time or second time, go to the court manager and give it to them and get them to check it for you. That way you know it's right, because if it's not, it keeps going back and to and forward and whatever. Then you just sit and you wait for a court date to come through. In our area, that's about 6 weeks. It might be, if it's just after Christmas, it tends to get a little bit longer than that, but there'll be a timescale. If you haven't heard anything in a couple of weeks regarding a date, your date will be 6 weeks, but you should hear something in a week to 2 weeks. If you've not heard anything, get on the phone, chase them, because they do lose stuff. And if you just sit there, it's time ticking. It's ticking, ticking, ticking. So there we are. You wait for the date, usually about 4 to 6 weeks. On that date, you appear at court. If you're an agent, you take the landlord with you. We do not have right, as an agent, the agent does not have a right to appear in court for you. They have to apply for a right of audience. So they need you to go with them. The only people that can go is barristers, solicitors, or yourself. But they can go with you, and they can act for you, and they can talk for you as long as you're there. Appear at court, and you ask, when you're in the court, you tell them the case, you give them the ledgers and all the rest of it. Ask for 14 days possession. Could ask for immediate possession. You're unlikely to get it. And what that means is the judge has the right to grant possession up to 6 weeks. Now, you don't want him to grant you 6 weeks possession, do you? That's another 6 weeks they can live in your property rent-free because they're not paying. So you want to get them out immediate or as soon as possible. We had a spate a couple of years ago. We were getting immediate possessions on nearly every case. We're not getting that now. We're getting 14 days. So we just ask for 14 days now, 14-day possession. Please, sir, can we have 14-day possession? And they generally grant it. So you've got your possession order now. You go home, you're all happy, and you sit and you wait for the 14 days. 14 days later, we find in about 90% of cases they go. Sometimes they won't. Now what happens now with the councils? If they want a council house, the council will actually tell the tenants, we cannot give you a council house until you've got the next level, which is the bailiffs. Isn't that mad? It's common. So the tenant might be on the phone saying to you, can you get the bailiffs around because we can't get a house until we've actually got that. Okay, fine, whatever. Go for it. So then what you have to do is you have to get something called, I love the name of this. This is a beautiful name. The warrant of execution. Isn't that a cool name? Going back to the treason slides earlier. Anyway, you have to go and get a warrant of execution, which basically means a bailiff order. That's where you want to get the tenants out. That's usually about 7 to 14 days. The bailiff will attend the property. Hopefully you will attend with keys, let them in, and the tenant will normally at this stage be gone. I think we've had a couple of cases where they've not been gone at this point, but they're generally gone. If they've got dogs, you need to arrange dog handlers, etc. If you haven't got keys, you need to arrange a locksmith anyway to change the locks, but you need to get all these people there on the day. If you think there's going to be problems, get the police to attend as well, if you can. Usually a couple of weeks later they're gone, they're evicted, and then you can do what you want to do with the property. So it's not simple, it's not difficult, is it? No, it's quite a simple process. It is, honestly. Where people get it wrong is with the paperwork's wrong, and they get stumped then. Get your paperwork right. We've been doing evictions for 20 years, and we've never, ever lost. Never. I was talking to a solicitor the other day, and I said, must have lost. We've never lost. And, maybe we've been lucky, but it's down to the paperwork and keeping it right. And, we had one once where a fairly new property manager, it was the first time he'd attended court on his own, a guy called Gary. He got a bit of a twitch, Gary. He's a funny guy. He got twitch all the time. I don't know if it had any impact. But anyway, he went up to the court and he came back and he went, the judge has given them 28 days to pay. I said, what do you mean 28 days to pay? I said, you've gone on a mandatory ground. The judge has got to award possession. Judges quite often do not know the law. It's your job to tell them what the law is. Is that scary? Now, you must never intimidate a judge. Never put them down. Never be rude. So you go, in that situation, I would like to give them 28 days to pay. I'm sorry, sir. You actually have to award possession. We're on a mandatory ground. And all the paperwork is in order, I think you'll agree. Oh, okay, yes. So how much notice can I give? Up to 6 weeks, sir. But we'd like to apply for 14 days because the landlord's in mortgage arrears. Okay, 14 days. Those are the sort of conversations you need to be prepared to have. Do not think what they say is gospel because quite often do not know the law. So you need to make sure you're right. Anyway, Gary came back down. He said, they've given them 28 days for pay. I said, they can't do that. I said, get back up there now and get it relisted. He went back up there. They realised they'd made a mistake. They relisted it for the following day and we got possession. So it's about knowing your law. Knowing the law, knowing the ins and outs will really save your bacon. Really stop you making some very expensive mistakes. So there we go, very simple. How not to do it? Okay, now sometimes you might need a little bit of help. As in, if you're in mortgage arrears, you're more likely to get a quick possession than if you're not in mortgage arrears. However, if you turn up in an Armani suit with a diamond-encrusted Rolex, with the shiny shoes, looking very dapper, playing with your phone on the way in, all the rest of it, you're probably not going to be able to pull that one. And we had a landlord called Greg, lovely chap. He failed to turn up at the first court hearing because he forgot about it. So he had to relist it. He turned up at the second one, and I said, Greg, please don't turn up in your usual attire. But he did. And we did get possession, but it was like, oh, Greg, please, what are you doing? Because sometimes it helps, But anyway, that's not how to do it. Don't argue with the judge. Don't make him look stupid. And be clear in what you want. Be clear in to ask him for 14 days possession. Okay. Has that helped? A bit of legal there?
Yeah.
We all awake?
Yep.
Yeah, sure? Yep. Fantastic. Just checking. It's hard work, legals, isn't it? Okay. Gas certificates. I hope you all know that in rented property in the UK, you've got to do a gas certificate. Do you all know that?
Yeah.
Fantastic. Here's some of the more intricate details of gas safety. Now, this particular training module will actually take about 4 hours normally, so you're really getting a fast-track version here. Okay, gas safety, installation and use regulations first came out in 94, then 96, and revised in 98. And it was brilliant for us because when we first got gas safety out, landlords just wouldn't do anything. I'll tell you a little story. We had a house that was converted into 3 flats, and we had a tenant moved into all 3 flats. and the landlord had not done any gas safety certificate at all because there was no requirement to do. The gas regulations came out, and we did a gas safety certificate on his property. Now, we've got 3 tenants living in his property. The gas fire to the ground floor went up the flue. The flue at the top was partially blocked by a bird's nest, and in the top floor flat there was an air vent going into the tenant's bedroom. Was I glad we had a gas certificate? And it's just a typical example. Even modern houses, flues can collapse, and you won't know about it. So gas safety certificates are really, really important. Who's liable for gas safety if you don't get it done? You are. Now, you might be able to sue your agent if they're negligent, but ultimately you're responsible. So you've got to make sure it's stuff done. You should have this in every file for your properties without fail. Now, yes, you've got to do a gas check every year. You've got to schedule your further gas checks. You've got to keep those records for 2 years. So is your gas man got to keep those records for 2 years. If you lose it, he should have it. Your agent should keep those records for 2 years. I was talking to somebody earlier who said they'd lost it. Not acceptable. Okay, they've got to keep those records for 2 years. It's a legal requirement that every tenant has a gas safety certificate before they move into a property. Do we all do that? Yeah, hopefully you do. But you've got to give it to each tenant. If you've got 4 tenants, give them each a copy before they move in. And hopefully that gas certificate says pass on it, not fail. You'd be surprised. Some people don't check that bit. It's a gas certificate.
Is it called a gas certificate?
Gas safety certificate, yeah.
Has it got a number?
No, just gas safety certificate. You've got to make sure that the gas safety certificate guy that's done it for you, the gas engineer, is registered with Gas Safe. And you can do that by going onto the Gas Safe website, typing in their name, area, and it'll come up with their registration number. But also, any work that you do at the property regarding gas, you might change a gas fire, change a boiler, cap something off, put a new cooker in, whatever, that needs to be checked as well. And those records have to be kept for 2 years. And if you've got a gas contractor that goes out and does something, you've got to check that they're actually authorised. It's your responsibility to make sure that gas engineer is a gas safe qualified engineer. But something that surprises a lot of people is that gas engineers aren't qualified to do anything to do with gas. They might be gas safe, but they might only be qualified to do checks, which means they can't fit a boiler for you. They might not be qualified to do warm air, or they might not be qualified to do combination boilers. So you've not only got to know they're gas safe registered, you've also got to know what work they're qualified to do. Has anybody ever checked that? It's important stuff. Because who's liable? Who's liable? You are, absolutely. So you've got to make sure you check this stuff. And agents, it's their job to check this stuff as well. This is great fodder for getting your agent back, you know, if they're not doing all this. Excluded leases. Now, if your lease, I'm sure you guys are not going to be doing these, but if you've got a lease that's more than 7 years, you don't actually have to do gas certificates, but I'm sure that's not going to be the case here. However, if that lease is determinable within 7 years, as in can be ended within 7 years, then you do. So if you've got an 8-year lease, but you can get out of it after 4 years, you do have to do gas certificates. There's also something called excluded appliances. There's relevant appliances and there's excluded appliances. Relevant appliances means appliances that you are responsible for, and sometimes there's a grey area with this. You might think, well, anything I stick in there I'm responsible for. Yeah, you are. But what about if the tenant puts a new cooker in? Who's responsible then? And that's where you come to excluded appliances. Now, the answer to whether you're responsible or not is not clear-cut. The question you need to then ask yourself and document in your file somewhere is the tenant intending to take that gas appliance with them when they leave? If the tenant is going to take that gas appliance with them when they leave, then the tenant's responsible for it, not you. But if the tenant is going to leave it when they go, who's responsible? You are. Yeah. So the question is, who's going to own that gas appliance when they go? There's also something else you should consider as well. If they're fitting a gas appliance onto your flue, you might be responsible for that flue. So if you say, oh yeah, that's fine, and then you find out that the flue's collapsed and it needs a couple of £1,000 to re-sort it out, who's going to be liable for that? You are. So generally, the answer when someone says, can I fit my own appliance, is what? No. Because you don't want the responsibility. It's just not worth it. We certainly say no in most cases. Must not contract out. There's a very large company in our area. I'm not going to mention them because we're recording. But they, when the gas certificates first came out, decided to write to all of their tenants and tell them that it's not our responsibility to get the gas certificate done, it's your responsibility to do it. Please make sure you get the gas certificate done and forward us a copy. Do you think that was right? I'll tell you in the break who it was, but I can't mention it here. Absolutely not. It's not right. You cannot contract out your responsibility under the law. Why? Because statutory law says who's responsible? You are. So you can't contract out that obligation. It's down to you to do it. So therefore, you cannot do that. If you've got appliances in bedrooms and bathrooms, this is something to consider when you're doing, when you rent to, normal family, and then you get 3 people move in and they want to use the lounge as a bedroom. Have you got an open-fronted fire there? If you have, they can't use it as a bedroom. You've got to get that fire capped off. So you'll be very careful. So you've got to be looking at bedrooms and bathrooms being room-sealed appliances. And they've also got to be less than 14 kilowatts as well in bedrooms. This is all technical stuff. You just need to be aware there's something you need to remember with regards to this. If you get 3 people moving into a normal house and they want to use the lounge, just have a look at the fire. Also beware of change of use, as we just mentioned about changing the lounge into a bedroom. And the penalties, as you all know, £5,000 fine or 6 months in jail. There's just been a landlord's just been prosecuted for 12 cases of this, had a HMO with 12 tenants, got prosecuted 12 times. A hefty custodial sentence and a heavy fine. I can't remember the figures, but pretty severe. So you've got to be careful on this one. Imagine if you got 240 expired. Ouch. You'd be away for a long time, wouldn't you? Okay, whoops. So you do everything you should do. You carry out your gas safety check. The landlord, as in you, then turns one very big lounge into 2 rooms. Big room into 2 rooms. Sorry, they put a partition down the middle and they convert 1 through lounge into 2 rooms. They also fit double glazing. You do an inspection and you notice that the tenant's now sleeping in the lounge. What do you do? Move them out of the lounge, yeah, you could do. What if they refuse? They say, no, we want to use this as a bedroom. What are you going to do?
Well, you have to stop them doing it because it's illegal, because it's right next to the gas fire.
So what you're saying is it's legal, you'd have to stop and do it because it's right next to the gas fire. It is. This is true. Any other? Cap the fire. Exactly. What you need to do is you need to check. You need to check that gas appliance. You're not a gas man. It's not your responsibility to know the law of gas. You've just got to know there's something I've got to do here. You get a gas man out, he'll look at it, he'll cap it off, and the property will be safe again. And that's generally the answer, cap it off. So get the gas man out, get him to cap it off. But if you've actually changed the use of a room or changed the format of a room, one of the requirements under gas safety is combustible air. That's the amount of air that's drawn into the fire. And if you've turned a big lounge into 2 rooms, you've just halved the amount of air that fire's got, haven't you? So you need to recheck the gas safety. Any changes like that, double glazing is another one because you're reducing the drafts. Putting a door on, which was previously open, is another one. Any changes like that, you need to redo the gas certificate. Just silly little things. You don't need to remember all this stuff. Just remember you've got to do something. Okay?
We also advise our clients always to put a carbon monoxide monitor in there as well. Just
Brilliant.
belt braces.
Yes, so Phil's just saying he always advises people to put carbon monoxide poisoning detectors in there. It's brilliant because that is the biggest killer, isn't it? Biggest and silent killer. They're only a few quid, aren't they?
Yeah.
What do you pay for them?
15 quid.
15 quid.
For a good one.
It's just not worth not doing it, really, is it?
If you get the fire department in,
Yeah.
they'll just do it for you free.
Yes, they will.
Do a 10-year battery-free one.
Okay, brilliant. And we're just saying that if you get the fire safety in, they'll do it for you for free and they'll give you a 10-year battery. I don't think all areas do it for free, but a lot of them will. It depends on their resources. But it's certainly a good resource, the fire office. They will come and do checks for you. They do, this is true. We're going to cover that in a bit. Okay, so the next one I want to cover, and I've just been told we've got 10 minutes of time. Question at the back quickly? Yeah? Okay, where there's oil fired, you should still do a check every year. I'm just going to come on to that now if we can. Yep, no problem. The next act I want to talk to you about is the one, we love this one, Dawn, don't we? Consumer Protection Act 1987. This is the catch-all answer to everything. Now, you should all know the Consumer Protection Act of 1987, particularly Section 19 and Section 39. These are the 2 acts that if you do anything wrong, they'll get you on. These are the ones that will send you to jail and cost you a fortune. These are the ones that cover all the things that aren't covered in the other regulations, like the gentleman just said at the back, the oil regs. There's lots of regulations out there, gas regulations, electric regulations, fire and safety regulations, plug socket regulations. There's even a bunk bed regulation. Did you know that? Have you got your bunk beds checked recently? But anything that isn't covered by a more specific regulation is all covered, and a lot of those come under the Consumer Protection Act 1987. What this says is that if you do not, it's your responsibility rather, to ensure that your property is safe for humans, animals, and not to cause damage to property. How broad is that? That covers hanging baskets hanging loosely, that covers slabs that are sticking up, that covers carpets that are frayed, that covers oil boilers, that covers absolutely anything that isn't covered by anything else. If it's not safe, who's liable? You are. And it also says that it is a defence, and it would be a defence in court to show that you have taken all reasonable steps to avoid committing the offence. You've done everything you could to avoid committing that offence. Everything. And this lady just said at the front here about smoke alarms. We insist on all of our landlords having main smoke alarms. We don't allow batteries for exactly the reason you've just said. People stick them in the drawer, take the batteries out, throw them away, whatever. Question for you. Now you know the Consumer Protection Act. It's your responsibility to say that property is safe at all times. Question for you. If the tenant's taken the battery out and there's a fire, is the property safe at that time? Have you as a landlord done everything you possibly could have done to ensure that property was going to be safe at that point in time? No. Sorry? The question is, would that depend on whether you've done regular inspections as well? See, what you're talking about there is a defence in court. Absolutely. If you can go to court and say, I gave the tenant a battery smoke alarm, I gave them 6 batteries, I check it every time I go round, I've written it on the inventory, that would be a defence in court. The question is, would you win? I don't know the answer to that. Because when it comes to the law, it's down to the judge on the day. And the thing is, if they've got a few other bits to tag in there, you might not win. If somebody dies, you might not win. If it's not very serious, you might. And so the question is, have you done everything that you can do to make sure that property is safe? And that relates to everything. We make people take greenhouses down, we make them fill in ponds, we make sure the spindles are not too far apart, carpets are frayed, we make them replace them, etc., etc., because this Act covers everything. Got to be very careful. Now, something else is regarding to electrics. At the moment, there is no law that says that you have to have electrical inspections. So, I haven't got it on there, but if you were to move a tenant into a property. Now, this is a very nice tenant, he's very friendly, he's lovely, and he moves into your property. A few weeks down the line, he decides to cut the plug off and stick a dodgy one on. It's all frayed. He smashes a socket. And he goes to the health and safety executive and goes, look, 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 I could have died, my little Jimmy nearly poked his finger in, his hair's gone curly. You then are in court. Now, remember the previous one? It is a defence in court to show that you have taken all reasonable steps, okay? In court now, on the court day, little Jimmy's there with curly hair, because he had straight hair before. He's got photographs to prove it. And he's got proof from the health and safety executive that it was an frayed plug and the socket was smashed. What evidence do you have if you have not done an electrical certificate? Inventory. You can write down the inventory. You can also put down the plugs on the inventory. You can put down the fuses on the inventory as well, because you've got the plugs and sockets and you've got the plugs and sockets regulations as well. So you can put all that down on the inventory. Absolutely right, you can. Would that be enough defence in court? Might be.
Depends how good the inventory is.
It depends how good the inventory is, how long ago it was. Might be, it might not be. Now that is an actual case that was taken to court by the health and safety executive. And the landlord got fined £3,000 because there was an insufficient plug on the fridge and because the landlord didn't supply an instruction booklet for the fridge. That's the discretionary bit they've tagged on the end there. £3,000. Yes? Yes, PAC test would cover most of it. What you want, and what we insist on landlords doing, is having a landlord's visual electrical inspection, which basically is we want a third party to say, yep, the fridge is there, yes, the plug's right, yes, the fuse is right, tick, tick, tick. They check the sockets, they do the PAC test, they do the cross-bonding, gas bonding, and water bonding. You just want an electrician to say, yeah, everything's fine. Visual inspection you can probably get for about 50 quid. Now, you want to do your NICIC or your NAPIT test, which is your 5 or 10 year electrical inspection. You do that anyway, just because you want to know your wiring's safe and the property's wired properly, etc., etc. But it's good to have a visual inspection done every year or every change of tenant, whatever, just so you've got a defence in court. Yes, you can put it on the inventory, and that's also another process to put it on the inventory, but make sure you write everything down, because it's always the bit you miss that they get you on. Okay? So, Consumer Protection Act 1987 is a brilliant one, isn't it? Good one? Is that a good one to be aware of? Yeah, very much so. Okay, so to summarise then, we're coming to the end now. Ensure that you use the correct agreements. So remember, are they an individual? Are they a human being, an individual? Is it the main or principal residence? Do they have exclusive possession? Etc., etc. Then you've got to make sure that you use the right contract. Because remember, in statutory law, you can't overrule statutory law. Be swift and fair throughout the court process. Be organised with your gas certificates. Understand your obligation to provide safe accommodation. It's your responsibility and it applies to everything. And also, don't get duped by greedy tenants, because they will take you to court. And it's not about whether the law says you've got to have this. Quite often it's defend yourself against the tenant. I call it CYA, cover your arse. Because if you don't, no one else will. That's it for me. Thank you very much.